1999, a 5,000 log tower stacked 59 feet high collapsed on the Texas A&M campus, killing 12 and injuring 27. Now, in the subsequent fallout, dozens of lawsuits were filed against Texas A&M, its administrators, contractors, and student leaders. The courts were all over the place on this. One thing they agreed on was that Texas A&M was protected by qualified immunity. You've heard me say that on here. Governmental actors and entities protected as a result of qualified immunity means you can't bring suit against them. So most of the suits against A&M were resolved that way. But of the rest of those cases, many of the contractors and student administrators were settled out early. There was one case that remained. It hung on until 2008. It was one of the cases against A&M. And oddly enough, they actually settled that for several $1,000,000, but did not admit fault. So very interesting, tragic case, but a cautionary tale. Just because you think something is a sponsored event at your school doesn't mean that they are going to be held liable if they're responsible. Now, this had been going on for 80 years. It was a student tradition, but there was a lack of oversight. It was a lack of engineering. Quite frankly, it was a dangerous condition. School just happened to get lucky and be protected. So exercise caution even at school-sanctioned events.